Imagine this. Across the country, millions of Americans are watching as courts twist themselves into knots to justify bans on something that is not exotic, not rare, and not military hardware. We are talking about magazines that hold more than 10 rounds, the same magazines that come standard with the most popular firearms in America. In Washington state, the highest court just upheld a ban on these items, even while admitting they are owned by tens of millions of people. That decision has pushed the issue to the national stage and set the stage for what could become the most important Second Amendment case since Bruen. The numbers tell the story. Nearly half of all American gun owners possess magazines that hold more than 10 rounds. That means tens of millions of citizens, all law-abiding, are being told in some states that they cannot keep something that is normal everywhere else. Researchers estimate that Americans own over 500 million of these magazines. The Glock 17, one of the most popular handguns in the world, ships with a 17-round magazine. The AR-15, the most popular rifle in the United States, is designed to function with a 30-round magazine. These are not exotic add-ons. They are the standard equipment of modern firearms, and calling them large capacity is nothing more than political spin. And yet, despite how common they are, the Washington Supreme Court insisted that these magazines are not arms under the Second Amendment. Even if they were, the court claimed they are not commonly used for self-defense. That argument is a contradiction. The court admitted millions own them, then turned around and said they are not protected. That is not careful reasoning. That is legal gymnastics designed to reach a predetermined outcome. It is exactly the sort of maneuver that has driven 26 states to come together and tell the United States Supreme Court to intervene. To understand why this moment matters, you have to look back to 2008 and 2022. In Heller, the Supreme Court said the Second Amendment protects firearms in common use by law-abiding citizens for lawful purposes. In Bruen, the court went further and declared that governments cannot invent new balancing tests. Instead, they must prove any gun regulation is consistent with America's historical tradition. That requirement is known as the Bruen test. In plain terms, if a government wants to restrict a weapon or an accessory, it has to show that similar restrictions existed at the time the Second Amendment was adopted. If no such example exists, the law fails. Washington has not been able to provide any relevant precedent, so its courts simply added new language, claiming that an item has to be commonly used in self-defense. That is nowhere in the Constitution, nowhere in Heller, and nowhere in Bruen. Magazines are not optional. They are integral to the design of nearly every repeating firearm in the world. A semi-automatic pistol without a magazine becomes a clumsy single-shot weapon. A rifle without its magazine is useless for its intended purpose. Pretending otherwise is like pretending a car without a fuel tank is still fully functional. The Constitution protects arms, and the components necessary for those arms to work cannot be stripped away by creative word games in state courts. This is not just a debate among lawyers. Ordinary Americans feel the consequences directly. A citizen in Texas can legally own a Glock 17 with its standard magazine. That same citizen in Washington would be labeled a criminal for owning the exact same thing. The result is a patchwork of laws where rights evaporate the moment you cross a state line. That is not equal justice under the Constitution. That is a nation where basic freedoms are treated as privileges to be granted or denied by politicians and judges. Unless the Supreme Court steps in, the Second Amendment will become meaningless in entire regions of the country, leaving millions defenseless against overreach. That is why this case is not just about Washington. It is about whether the Constitution still means what it says. The case moving now is Gator's Custom Guns v. Washington, born from Washington State's decision to outlaw magazines holding more than 10 rounds and the state Supreme Court's approval of that ban. The ruling did not end debate. It ignited it. 26 states filed an amicus brief urging the United States Supreme Court to take the case and rein in lower courts that dodge precedent. Montana and Idaho led the effort, joined by Alabama, Alaska, Arkansas, Florida, Georgia, Iowa, Indiana, Kansas, Kentucky, Louisiana, Mississippi, Missouri, Nebraska, New Hampshire, North Dakota, Ohio, Oklahoma, South Carolina, South Dakota, Tennessee, Texas, Utah, West Virginia, and Wyoming with the Arizona legislature also signing on. The message is simple: restore a national standard. Magazines over 10 rounds are not exotic add-ons. They are integral components of the most common modern firearms. You do not use a semi-automatic pistol or rifle as designed without its magazine. For that reason, the states argue magazines fall within the Second Amendment's protection of arms. The brief leans on Heller's common use principle. When tens or hundreds of millions of law-abiding citizens possess an item for lawful purposes, it cannot be banned as though it were unusual in the constitutional sense. Popular handguns ship with magazines above the 10-round line, and popular rifles are engineered around 30-round magazines. That reality will not vanish. Layered on top of Heller is the Bruen test from 2022. Any modern gun restriction must be justified by a comparable historical tradition. If history does not support the regulation, the law fails. Washington's move, the states say, was to invent a requirement that an item be commonly used in self-defense. That phrase appears in neither the text of the Second Amendment nor the court's opinions. The right protects arms commonly possessed for lawful purposes, not only those brandished during an actual defensive incident. Elevating self-defense use over lawful possession rewrites the standard. To make this concrete, the brief compares magazines to other necessary components: a pistol's barrel, a rifle's receiver, a revolver's cylinder. Remove any, and the arm ceases to function as intended. A magazine serves the same role for a modern repeating firearm. It is the feeding system. You can hand-load a single round, but that is not the designed operation. Courts that label magazines mere accessories are playing semantics to reach an outcome Bruen does not allow. The coalition also invokes McDonald v. Chicago, the 2010 decision that applied the Second Amendment to the states through the 14th Amendment. That incorporation principle prevents state courts from hollowing out a federal right by redefining its terms. When one state treats a standard magazine as contraband, while another treats it as ordinary equipment, rights shift at the border. Constitutional guarantees are not supposed to flicker on and off. Meanwhile, conflicting rulings from federal appellate courts amplify the confusion. The Fourth Circuit has minimized the AR-15's status under the amendment. The Seventh Circuit has equated AR-15s with military M16s to justify bans. The First Circuit has waved away popularity as irrelevant. Each move clashes with Heller and with Bruen's historical tradition requirement. Predictably, states hostile to the right lean on those opinions, while others reject them, and citizens are left with a patchwork that punishes geography rather than conduct. That uncertainty is what the coalition asks the Supreme Court to end. Take the case. Say plainly that magazines are part of the protected arms of the people. Reiterate that courts may not replace history with interest balancing or word games. Clarify that common use applies to arms and to the essential components without which those arms do not function. Restore a uniform standard so a citizen's rights do not evaporate at a state line. The stakes are high because millions already own these magazines lawfully, and the Constitution does not permit governments to criminalize the ordinary. A clear ruling would end the games and bring the Second Amendment back to baseline. Washington tried to defend its ban by pointing to history. But when you look closely, the comparisons collapse. They cited trap gun laws, but those laws were never about bearable arms. They were about outlawing dangerous booby traps that could harm anyone who stumbled across them. They brought up gunpowder storage laws, but those were fire safety measures designed to keep towns from burning down, not efforts to disarm citizens. Then they pointed to restrictions on Bowie knives, but those came decades after the Second Amendment was ratified and were not outright bans on ownership. In many places, those knife laws have already been overturned. None of these examples bear any resemblance to stripping millions of law-abiding citizens of the standard equipment for their firearms. That is why the state's argument looks weak when held against the standard the Supreme Court itself laid down in Bruen. The weakness of Washington's case is important because it highlights the larger problem. Courts in Illinois, Rhode Island, Massachusetts, and California have all upheld similar bans. Each of these states claims to be regulating dangerous items, but what they are really doing is inventing new legal categories to avoid the plain text of the Constitution. The result is a patchwork of laws that turns constitutional rights into privileges that change with geography. You can be a law-abiding citizen in Texas and a criminal in California for owning the same magazine. That is not how freedom works. That is not how the Bill of Rights was written. The Supreme Court has already provided guidance. In Caetano v. Massachusetts in 2016, the court unanimously struck down a ruling that said stun guns were not protected. At the time, only around 200,000 people owned stun guns, but the court still declared that they qualified as arms. That decision reinforces what Heller had already said: if an item is commonly possessed by law-abiding citizens, for lawful purposes, it is protected. If 200,000 counted as common, then the hundreds of millions of magazines owned today cannot be dismissed. Lower courts pretending otherwise are not applying precedent, they are defying it. What ordinary Americans see is simple. They know magazines are not optional extras. They are the core components of the firearms they bought legally. They understand that when a state labels these items contraband, it is not protecting safety, it is punishing citizens who did nothing wrong. They also know that allowing activist judges to redefine arms at will sets a precedent that could erode other rights too. If the meaning of the Second Amendment can be shifted by wordplay, the same logic could be applied elsewhere in the Bill of Rights. That is why this case carries weight beyond firearms alone. This is the danger of a nation divided by a patchwork of bans. It is not just confusion. It is an erosion of equal protection under the law. One group of citizens enjoys the full protection of the Constitution, while another group living across a state border is told those same rights do not apply. The founders never intended for basic freedoms to function like that. The Bill of Rights was written as a national guarantee, not a regional option. The responsibility now rests squarely on the United States Supreme Court. 26 states have spoken loudly, filing their brief to demand clarity. The American people are watching to see if the court will finally settle the magazine issue and reaffirm that the Second Amendment still means what it says. A strong ruling would restore consistency, bring lower courts back into line, and protect the rights of millions. A refusal to act would embolden hostile jurisdictions to keep pushing further, knowing there is no consequence for defying precedent. This moment is about more than Washington, more than magazines, and even more than firearms. It is about the integrity of constitutional rights. Either they are applied equally to every citizen, or they are no rights at all. The Supreme Court now faces a choice that will echo for generations: enforce the standard it created, or allow rights to be whittled away by states that never wanted to recognize them. History will remember which path is chosen.